Hello and welcome to Legally Speaking with me, Tarun Nangia. Today we discuss a very interesting topic, that is whether the Serious Fraud Investigation Office, which is nomenclature as the SFIO under the Ministry of Corporate Affairs, can it investigate offences under the Indian Penal Code, also known as the IPC. This will become very interesting because already the IPC offences are investigated by the police department. And if the SFIO can also investigate IPC offences, then what's the ripple effect of such a decision? Are there any court judgments in this regard? All of this and more will be decoded to you by my panelists on the show today. Let me welcome Advocate Neeha Nagpal, founding partner and in-law chambers, Advocate Malak Bhatt, founding partner and in-law chambers, who work on a lot of these cases. They will decode this topic for us. I'll go to Advocate Malak Bhatt. Can you please, in the next 3 to 4 minutes, lay down the ground for this episode, some case citations, and the big question whether SFIO can investigate IPC offences?
Right. Thanks, Tarun, for having us. So recently there has been a development in this field where the Delhi High Court in two judgments, the first being a judgment in the case of Ashish Bhalla, and recently in the case of R.K. Gupta versus SFIO, has held that the SFIO, the investigating body under the Companies Act, does have the power to investigate into IPC offences. Now, what are the effects of this? We'll come to in a minute. But R.K. Gupta was also taken in appeal to the Supreme Court, and the Supreme Court has dismissed the SLP. So, to that extent, the view of the High Court stands affirmed. Now, what is the reasoning that the High Court has gone into? High Court says that, look, as a body which is investigating into the affairs of a company, because as we know that under the ambit of Section 212 of the Companies Act, the SFIO initiates investigation once the Ministry of Corporate Affairs entrusts the investigation on it, while it is investigating into the affairs of a particular company, and the ambit of those will be offenses under the Companies Act. If it does come across that the same transaction may also lead to offenses under the IPC, then it is not a body which is left powerless to not look at that offense. And the reasoning it gives is from a purposive interpretation of Section 212, a couple of subsections within that, to say that since the ambit of the investigation is that you are looking into the transactions and the affairs that the company has overtaken in the period under investigation, if the same kind of transactions lead to offenses which are outside the purview of the Companies Act, SFIO is not bereft of looking into this. Now, how is this different from other cases? Is because unlike police or the CBI, which has police powers, the SFIO, just like the ED under the PMLA or the GST, the DRI or the Customs Act, is a investigating body as a creature of statute. It is a body created under that particular statute for purpose of investigating that particular statute. Now, since the Delhi High Court has given them the additional power that, look, you can also investigate into IPC offenses, they are now bridled with what one would call the cloak of being a police officer, which also, these judgments talk about, and we'll come to that later. The interesting question that now comes across is A, the ambit of the power, B, is this only to curtail multiplicity of investigations, and see the larger repercussions as to what will happen when a body like SFIO now goes ahead and charges you with IPC offenses before a court of law where you will be ultimately tried for these offenses under law.
Okay, thank you for that opening comment. Now, the question that arises is, before I take Neeha Nagpal's opening comment, is that there were a lot of questions on multiplicity of agencies which are investigating accused for the same offense. What happens in the background of the judgments that Malak Bhatt has averred to? Neeha Nagpal, could you address these questions in addition to your opening comment?
So, thank you for having us, Tarun. It's always a pleasure. Yes, I think what you're raising as a question is something that has been bothering all of us as practitioners as well, especially on the white collar crime side. Day in, day out, we see the impact of multiplicity of proceedings that happen between SFIO, CBI, EOW, and ED on various entrepreneurs and businesses. Um, and it creates a sense of confusion. It creates a sense of uh, stress and anxiety for sure, but also a paucity of data, which becomes very difficult for a client to be providing to multiple agencies because the first raid, the data is all taken. That is on the logistical side of things. On the legal side of things, Section 212 of the Companies Act, which basically creates the SFIO and empowers it to investigate, says that if SFIO is looking into the affairs of investigating into the affairs of the company, no other agency shall look into the affairs of the company. The provision per se puts a limitation that under this act, implying the Companies Act. But the Delhi High Court in Ashish Bhalla's judgment has kind of taken it a notch further and said that quashed an FIR, wherever by EOW, wherever IPC offenses against a company, saying that these are now also, this matter is being looked into by the SFIO. And there cannot be two essential complaints, charge sheets, investigations on the same set of allegations. So the FIR was quashed on that basis. As things stand thus, and then reiterated by the Delhi High Court in R.K. Gupta's judgment, that yes, the SFIO has powers to look into the IPC offences also, which was then the R.K. Gupta's judgment was upheld by the Supreme Court, as Malak pointed out, with a limited question on whether the officers are police officers in terms of the IPC, etc. That with that limited question being open because that's already pending in Supreme Court. What it does is, at least we hope that it will reconcile the position of multiplicity. The harakiri should now stop where if SFIO has come in, let SFIO look into everything. Multiple FIRs by CBI and or EOW, as the case may be, should now be restricted to one agency. Unfortunately, that's not yet started happening. It should, and we really hope it does, because it will curtail the problem of multiple bails, multiple trials, multiple investigations, and multiple expenditures in terms of fees, etc. I think there has to be some amendment also formally to maybe the the Companies Act to enable this provision if the judgments are not being given effect to. The second limb of the problem is that these are all judgments by right now the Delhi High Court, not as such the Supreme Court per se. Of course, R.K. Gupta has been upheld by the Supreme Court. So different states may take different views. So we need a consolidation of position. So therefore, an amendment to the Act saying that 212 is clarified to the extent that SFIO can also look into affairs of the company and IPC offences would probably pave the way for consolidation and avoid multiplicity.
Okay, point well taken. But from the point of view, if you only consider the judgment, I want to get Advocate Malak Bhatt in here. If you could share with us, can the ED step in and say we want to investigate IPC offences? If you go by the judgment which now allows SFIO, there will be a confusion in the minds of promoters that if what the only the police could investigate, now the SFIO can, does it then extend to other agencies where they will claim jurisdiction? What happens then?
Well, the straight jacket answer to this will be no. And you are also right that one can still try and, innovatively and creatively interpret these statutes under which the agencies, the bodies are set up to come and say that there is no restriction under the statute from me to go and investigate IPC offense. The predicament that the judgments create on one hand, while we understand that multiplicity and avoiding multiplicity is one thing, but the other thing which a lot of this misses out is that these are specific bodies set up under specific statutes for the purpose of conducting an inquiry. It is quite different from what an investigation would be. Because as you see, police investigation under the aegis of the CRPC has its own limitations, has its own restrictions, where there's a counterbalance between the rights of the accused with that of the police. The statutes, on the other hand, like the Customs Act or the GST or the TRI, or for that matter, even the Companies Act, treats these as inquiries for the purpose of fact finding, which is why there are powers given to them which you would not otherwise see powers given under the CRPC. For example, statements made to the SFIO under Section 217 are admissible in evidence because they say that you ultimately have the power of a civil court. You're collecting inquiry. In the inquiry, you're collecting evidence. So it's a evidence gathering mechanism. If that is the case, if the case is that you are ultimately only an investigating body, not looking into investigating the offenses, then you don't have to deal with the powers of the accused because these people are not accused as yet. Now, what happens is that you are going to be faced with a conundrum where you will be called in by the SFIO. You will be put to an inquiry under the Companies Act. You'll be told that, yes, I am collecting evidence for the purpose of seeing if you've committed an offense under the Companies Act or not. But at the same time, I will also add IPC offenses into this. Now, to answer your question, can other statutes, can other agencies look at it? My answer to that would be if you look at the Customs Act for a minute. The Customs Act, Section 3, Section 50, Section 26 say that it's an inquiry for the purpose of seeing if the person is guilty of the offense under the Customs Act. There is no provision like Section 212, which says that if SFIO is investigating and under this act, no other agency will deal with it. But on the other hand, there is no provision also which says that apart from the customs officer or the officers authorized under the Customs Act, no other person can look into this act, or that apart from Customs Act, the officer can't look at anything else also. So tomorrow, let's assume for a minute it's a case of let's take a case where the deemed export benefit of a company is wrongfully claimed, and therefore you are liable under the Customs Act for punishment and penalty. During that, if the customs officer finds that, oh, there is also a case made out of this person actually cheating the exchequer, can he add an IPC offense? My immediate answer will be no, because the read of the act does not provide it. But it still is left open in light of these two judgments. Because what may happen is, and this is the reasoning that the Supreme Court also came, because we were part of the Supreme Court hearing. Court says, look, ultimately these are private complaints. These are not charge sheets filed before the trial court, where the trial court takes cognizance and starts process. Ultimately, it's a private complaint by a person who just has the power to inquire, collect evidence. That person is presenting his complaint before the trial court. Let the trial court then collect evidence and see if the case is made out. So with that power, ultimately what you're doing is, in that hand of the private complaint, you are giving power under each and every statute. Whereas the counterproductive rights and obligations which they have for the accused are completely being watered out. And that's one answer which I think in the future Supreme Court will need to answer.
Point very well taken. I'll go to Advocate Neeha Nagpal. You want to add to what Malak said?
Of course, I agree with you, because I think there is, like right now also said, there is ambiguity. There will have to be some amendment at some point, or Supreme Court will have to come in and clarify, strike a balance between the rights of the accused, especially on the issue of whether the investigating officers under the SFIO are police officers or not. A lot will change if that on how that question is answered. More particularly, a lot will also change is whether the 212 section 2 power is limited only to the Companies Act, or they can deep dive into other provisions of law. If it is limited only under the Companies Act, then also one will have to see the impact it will have on other FIRs which are under the Indian Penal Code, etc., by CP and EOW. So I think the bigger problem that now one faces is the rights given by the R.K. Gupta judgment to SFIO to conduct further investigation. Because right now, the way the provision of Section 212 read, under Section 212(11), if the government wanted an interim report to be submitted, they would ask the SFIO to do so. But once a final report was submitted under 212(12), cognizance was once and for all given to file a prosecution. So, as Malak pointed out, it's an inquiry. That inquiry report by the SFIO is submitted to the government, the MCA. The MCA then has to give sanction to prosecute, which is given under 212(14). Now, to read into the provisions, to say that they have the right to further investigate, kinds of creates a little bit of a anomaly of a situation, because 212(11) does not, and 212(12) and 212(14), if read together, don't create this right. So Supreme Court will at some point have to intervene, or there'll have to be an amendment to clarify this position of law. Till then, we are going to be faced with a multiplicity and now a continuing investigation by SFIO, which can also have a cascading impact then on bail. Because as you are aware that under 2126 of the SFI of the Companies Act, SFIO bails are also have the twin condition. One, and upon filing of the complaint, the investigating report and the complaint, we always took a position now that investigation is complete. But now that the power of further investigation has very clearly been given, that will have a cascading impact there.
Point very well taken, because you alluded to promoters and bail becoming an issue. I'll go to Advocate Malak. But now, what is the situation of the promoters today? A, is it safely to tell them that multiple agencies A will investigate them, and secondly, bail will become more difficult than it is today?
So as far as the first question is concerned about multiplicity, I think the one good takeaway from this judgment, as I at least see it, is that they have themselves said that the agency under the Companies Act also look at IPC offences, meaning thereby, if there is, let's assume, so the two cases that we've seen till now, Ashish Bhalla, for example, as Neha pointed out, the FIR pertaining to the IPC offences by the EOW was quashed because the same offences were already forming part of the SFIO's ongoing complaint. Now, let's take a situation where there are investigations which are ongoing. There is a complaint or charge sheet file. There is a particular SFIO investigation, and there is an ongoing FIR where there is no culmination of investigation as well. Good takeaway from this judgment to that extent can be one can still approach the court and say, look, now in light of this judgment, the least you can do is you can transfer CBI's or the EOW or the police's investigation to SFIO. Since the nature of transactions that we'll be looking at are the same, direct the SFIO to also include whatever IPC offenses they have to look at. The flip side of that will then come on bail. Because as far as offenses under the IPC or even for that matter the Prevention of Corruption Act are concerned, there is no twin condition. As far as the moment you come to SFI, there is a 2126 clause which specifically says that to satisfy the test of bail, you have to prima facie show that you are not guilty of offense. Now, as the same is the reading as we've seen in the ED, and Vijay Madan Lal Chaudhary has upheld that particular provision under the PMLA, Section 45, the same section under the Companies Act, which today is pending and before the larger bench, but the wordings of the section the same. It today stands on the statute. So will then the SFIO get the power to add 126? Because the moment they investigate everything together, you're naturally bound to have a charge sheet which will have IPC offences and 447 fraud, the definition of fraud with the Companies Act. And 447 relates back to the twin condition. So even for offences which are not have the twin condition test, practically what will happen is ultimately you are going to seek bail if you're arrested in that particular complaint. Your bail for those IPC offences will also become tough. And that is the only, I think, counterbalancing act that will have to be done from a case-to-case basis. Because if there is merit to, or at least there is certainty that the investigation is going in a manner where the agency does not see the need to arrest you, then in cases like that, a clubbing of investigation by the SFIO is something that the promoters can consider to avoid facing two trials.
Yeah, but how will the clubbing happen?
So the clubbing in cases like this, for example, will happen if you see Ashish Bhalla, because SFIO had already looked at IPC offences, they quashed the FIR. They said the FIR need not survive because those very transactions, see, ultimately, in most cases, we've seen the transactions which are being looked at by the agencies are the same. It's either diversion of funds, it's siphoning. Allegations are always that, okay, there is a transaction from company A to company B, which today falls foul of 10 sections. Therefore, you have 4 agencies looking at it.
Yeah.
In the same leg, now the Ashish Bhalla judgment says, look, the same transaction is the fraudulent transaction under 447 of the Companies Act is also cheating under 420.
420.
Both sections the SFI has already looked at. So, Mr. EOW, what will you do now to finally go out? So let's
Point
take
well
it forward. Even assuming that this is at a stage where both agencies are investigating, theoretically now you can still go to court and say, look, either you tell the CBI or the EOW to stop the investigation, and you direct SFIO that they will also investigate the investigations.
Point well taken. So, Advocate Neeha Nagpal, I need to ask you here that if a promoter is investigated by Delhi Police, CBI, Enforcement Directorate, and SFIO, can he take up move an application to court requesting that only one agency be allowed to investigate?
Yes, absolutely. Because then all these either consolidation of the proceedings under 2122 or quashing of the FIRs as it was done in Ashish Bhalla's case. Because this amounts to completely multiple investigations, multiple trials for the same company, same transactions. See, the same transaction, as Malak rightly pointed out, could be foul of 447 of the Companies Act and foul of Section 420 of IPC. Thereby implying, if Companies Act is saying Company A gave a supply of material to Company B, which happens to be its related party entity, and actually instead of paying 100 rupees per quintal, was paying 120, so that 20 rupees is siphoning, that will be seen as cheating as well as fraud under 447, right, with 448 of the Companies Act. Why should somebody be investigated and then tried for the same period, same entity, same transaction, same time period? So therefore, Ashish Bhalla principle should apply to that extent, and multiple FIRs should be quashed, ought to be quashed, and that gives a promoter a right to do that.
Point very well taken. We're almost out of time, but I think we would like to take up this very topic in detail in further episodes, given great amount of interest in the business community who are at the receiving end of such prosecutions many times. It was an informative show. I would like to thank Advocate Neeha Nagpal, Advocate Malak Bhatt from NM Law Chambers for sharing the relevant judgments, what happens, also clubbing of investigations at one agency, that's possible. With bail becomes a bit tougher. All of that we learned today. More on this in the next episode. Thank you so much for joining us. Thank you so much for joining.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.